Welcome back to Counting to Five, live stream being broadcast live Thursday, April 19th, 2018 at 9 p.m. Eastern Time. And this live stream will also be posted as an episode of the Counting to Five audio podcast. If you're watching live, you can please feel free to ask questions in the YouTube live chat at any time, and I'll try to monitor it periodically and answer questions as they come up. And in these weekly live streams, we try to keep up to date with all of the latest Supreme Court news, the orders and opinions coming out of the court, and arguments that are coming up in the near future. Here's what I plan to cover in today's live stream. On Tuesday this week, the court issued 2 new opinions in argued cases. So in a little bit, I'm going to talk about each of those 2 opinions. Next week, that's the week of April 23rd, the court will be hearing oral argument in 6 more cases. Those are the last oral arguments of this term. So I will be previewing those 6 cases that are going to be argued next week. But first, before we get to all of that, some quick news about one of the justices, a final update on a case that we've been watching for several weeks now, and a new death penalty stay application. There's a lot to cover tonight, so I'm going to try and move pretty fast through everything. But again, if you're watching live and you have any questions, feel free to ask them, and I can go into more detail if there are any, if anyone wants me to on a particular issue or case. So first, just a quick news update. This week on Monday, that's April 16th, apparently Justice Sotomayor had a fall at home in the morning. She attended Monday's oral arguments, but in the afternoon was diagnosed with a broken left shoulder. She didn't miss any work, showed up at Tuesday's oral arguments with her arm in a sling, and apparently she's going to have her arm in a sling for a few weeks and is undergoing physical therapy to deal with the broken shoulder. Justice Sotomayor seems to be somewhat accident prone. She's had a few other bone breaks. In 2009, this was after she was nominated, but before she was confirmed to the court, she had a fall in an airport and broke her ankle. And then in 2014, she tripped on a sidewalk and broke several bones in her hand. Earlier this year, also in January, Justice Sotomayor was treated by paramedics at her home for a low blood sugar episode caused by her diabetes. So she's had a few, health issues, but again, nothing that seems particularly serious. She's after the low blood sugar episode, she was back to work that same day. So a minor mishap, it seems like, but apparently nothing particularly serious. So the latest update in a case that we've talked about several times in recent weeks, if you've been watching these weekly live stream episodes, the case of United States v. Microsoft. That case is finally basically over with at the Supreme Court. On Tuesday, the court issued a short opinion officially ordering the lower courts to dismiss the case as moot. And this was exactly what was expected to happen in this case. I've talked about this case several times, but here's a real quick summary of what this case is all about. The United States got a warrant in a criminal investigation. They got a warrant under the Stored Communications Act for emails that were stored in an MSN.com account. That's a Microsoft email service. Now, Microsoft refused to turn over the emails that were sought by the government, and they argued that the emails were stored in a server located in Ireland, and they argued that the Stored Communication Act didn't apply outside of the United States. Now, this dispute between the government and Microsoft over this extraterritorial application of the Stored Communications Act got all the way up to the Supreme Court and was argued earlier this term. However, on March 23rd, so just a few weeks ago, Congress passed something called the Cloud Act, which was part of the massive omnibus spending bill. That one of the many things included in that omnibus bill was the Cloud Act. And what the Cloud Act did was it amended the Stored Communications Act to explicitly allow access to electronic data stored outside the United States. Now, once this Cloud Act was enacted, after it was enacted, the United States went back to the court, obtained a new warrant under the provisions of the Cloud Act, and this warrant replaced the original warrant. Now, the original warrant under the old law is no longer in effect, So both parties, the United States and Microsoft, agreed that the case was now moot. There just isn't a live issue anymore because the old version of the Stored Communications Act is no longer the active law, and the warrant issued under that old version is no longer in effect. So they agreed that this case should be thrown out. And on Tuesday this week, the court did that and ordered the case to be dismissed. So that case is gone and out of the way. One final piece of news from earlier today. It's the latest death penalty stay application. Now, this was in the case of a man named Walter Moody, who was scheduled to be executed today. That's April 19th, 2018. Now, Moody was convicted of a 1989 murder by letter bomb of a federal court of appeals judge in Alabama. And he's 83 years old. This would be the oldest execution by about 5 years in the modern era of the U.S. Death penalty. Now, here's briefly, he made an application to stay his death sentence. And here's his basic legal argument. He was first convicted before he was convicted in Alabama for the murder of the federal judge. He was first convicted in federal court for a series of mail bombings that also killed a Georgia civil rights lawyer. And in the federal proceeding, he was sentenced in federal court to 7 life sentences and 400 years in federal prison. So you know, a life sentence there. While he was in federal custody, he was released to Alabama's custody for purposes of the state murder trial. And there was a condition of his release that he would be returned to federal custody after the conclusion of the proceedings. The Alabama trial concluded with the death sentence, and he was never returned to federal custody. Now, the U.S. had asserted that it still had primary custody and had the right to demand him back, but the government's official position and Attorney General Sessions issued a notice to this effect, said that the United States waived its right and consented for Alabama to retain custody for purposes of executing Moody. Now, Moody argued that there was no legal authority for Sessions to interrupt his federal prison sentence, and so this was unlawful order. Alabama came back and argued first, basically, that this was a habeas corpus petition. So that's a type of petition that argues that someone's being unlawfully held in custody, and it was a habeas corpus petition is directed to whatever authority is actually holding someone in custody. And here he's being held by Alabama, but he wasn't alleging that Alabama was the party that did something wrong. So Alabama is arguing you can't use this habeas petition to attack some other party, in this case the Attorney General of the United States' actions. But they also cited some case law saying that prisoners have no right to contest the order that multiple sentences by different governments are served in, that there's just no interest in saying that the federal sentence must be served before the state sentence or vice versa. Now, earlier this evening, Justice Thomas ordered a temporary stay of the execution. Justice Thomas is the circuit justice for the 11th Circuit, which covers Alabama, Florida, and Georgia. And when these stay applications come in, they go first to, because stays, they're often emergency situations that need to be acted on very quickly. They go to a single justice who has responsibility for the particular region that they come out of. And that, in this case, is Justice Thomas. Normally, death penalty stay applications are just, as a matter of course, are referred to the entire court for decision, and normally a single justice doesn't decide that on their own, and this would be referred to the whole court. However, Justice Thomas issued a stay, ordered this to be stayed. That suggests that there just wasn't time for the entire court to consider the application before they needed to, in order to, there was a risk that he would be executed before the court had a chance to really consider his application. So that was earlier this evening that Justice Thomas entered this circuit justice solo stay order. But then so around a half hour ago, the full court denied the stay application. So that's the temporary stay is lifted, and presumably this execution will go forward tonight. So that's just the latest in the never-ending stream of death sentence stay applications at the Supreme Court. Earlier this week, there were 6 oral arguments on 2 each day from Monday through Wednesday. These are the cases I previewed in last week's live stream episode. I'm not going to talk any more about them tonight just because there's a lot of other material to cover. But if you're interested in what those cases are about, you can listen to last week's live stream episode. The court did not grant any new cases this week. This is for next term. Right now, they're still at 8 cases granted so far for next term. That's the term beginning in October. That's the court's caseload in recent years has been at historic lows. This year, they're expected to issue only about 62 opinions in argued cases, which was extremely low. But this is part of a long-term decline in the court's caseload. Back in the 1980s, the court was hearing upwards of 150 cases a year, and that has declined in recent years, has been under 70 cases for several recent years. The court grants cases on a rolling basis throughout its term, and it needs, basically, just due to the time it takes for cases to get briefed. After the court grants a case, there's the parties file briefs, and there's a standard schedule of how much time each side gets to file its briefs before oral arguments. And just based on that, the court basically needs to fill up its fall calendar. That's the October, November, and December argument sessions before it leaves for summer recess at the end of June. And there's 17 argument days. If the court wanted a pretty full argument schedule, that would mean about 34 cases, hearing 2 cases a day. But in recent years, the court hasn't been hitting that and has had this lighter caseload, less than a full caseload in the fall arguments. So it's just something we're keeping an eye on, is these cert grants from now until the end of term, to see if this shrinking docket will continue, and if this is just going to be the new normal, that the court has these very light caseloads. So let's move on now to the opinions. The court had 2 new decisions in argued cases this week, not counting the Microsoft case, that short opinion in the Microsoft case ordering it dismissed, but actual full decisions. There were 2 cases, and this continues the very slow pace of opinions this year. The court is only up to 17 opinions so far out of, as I said, 62 that are expected, meaning there's 45 more opinions due to come down between now and the end of June. That's only 10 weeks after this week left. So that means the court, in order to get those all out, has to average 4 to 5 opinions a week. The term is always somewhat backloaded. The court issues more opinions in May and June than it does earlier in the term, but this term is kind of extreme in that regard. But we should expect a lot of opinions to start coming out from here on out through the end of the term. So let's move on to the 2 cases that the court decided this week. The first of those cases is called Wilson v. Sellers, and this case was 6-3. Justice Breyer wrote for the majority, and Justice Gorsuch wrote a dissent, joined by Justices Thomas and Alito. That was the 3 in dissent. Now, this is a little bit complicated, but I'm gonna try and kind of break down what it's about. It's purely a case about court procedures, and it's a criminal case, but it's not about the underlying criminal case or even the underlying constitutional claims that were raised in the criminal case. It's all about the court's procedures and how it goes about deciding, reviewing lower court decisions. So here's what it's about. So petition for habeas corpus is a petition seeking an order for the release of someone who's being held in custody unlawfully. And it's a mechanism by which various constitutional challenges to someone's criminal conviction can be brought, criminal conviction or sentencing. In the criminal context, habeas corpus, it's also kind of interchangeably referred to as post-conviction review. All right, just had another technical difficulty. The feed cut out briefly, but hopefully you're still with me. I was just saying that habeas corpus is also referred to as post-conviction review in the criminal context, and there are separate procedures there's what's referred to as state habeas or state post-conviction review and federal habeas. So when someone is challenging on constitutional grounds their conviction, they can bring both a petition of habeas corpus in state court and also in federal court. Now, what this case is about is a law, a 1996 law called the Anti-Terrorism and Effective Death Penalty Act, or AEDPA. Now, this law is referred to as EDPA. That's just how lawyers pronounce this act, this law. So EDPA, this 1996 law. There was a perception at the time that habeas corpuses, that most of the habeas corpuses that were being heard, habeas corpus filings that were being heard in federal court were frivolous. It was inmates who didn't have valid legal claims who were filing these abusive filings and just clogging up the courts with baseless claims. That was the perception, and that was what the lawmakers were reacting against. And the law was basically intended to fairly severely curtail federal habeas corpus actions in several ways. But habeas corpus and EDPA are incredibly complicated. Here, this case only deals with one very small aspect of it. But the important thing is, before someone can file a federal habeas corpus action, generally they have to first exhaust state habeas corpus procedures, meaning they have to file a state habeas corpus proceeding and fully go through all the state procedures before they're allowed to file that claim, a claim on the same grounds in federal court. Otherwise, if they go to federal court without having gone through the state procedures first, it's what's known as procedurally defaulted. Basically, the claim that they didn't raise first in the state proceedings is not allowed to be brought in federal procedures. So the point is, everything has to be funneled through the state courts first, and the federal courts want to give the state courts first pass at reviewing these claims, which are challenging a state court criminal conviction. Now, then once one of these claims gets to federal court, so it's been through state habeas corpus first, and then it gets into the federal habeas corpus, the federal court can only overturn the state court's ruling if it was, and this is some of the statutory language, if it was contrary to or involved an unreasonable application of clearly established federal law. So the federal court isn't just deciding from scratch if the state court got it wrong. They have to decide whether there was clearly established federal law and that the state was contrary to or unreasonably applied that clearly established federal law. So it's a very deferential standard that just says that unless the state was just clearly wrong in what it's doing, if they were arguably right when they issued their order, then the federal court has to leave it alone. Now, the issue in this case is how do you apply this rule? How does a federal court review whether the state court had involved an unreasonable application of clearly established federal law? How do they apply that rule if the final state court didn't explain its ruling? And I'll explain in a second what I mean by that. So let me give the basic facts of this claim. The criminal defendant was named Marion Wilson, and he was convicted and sentenced to death in Georgia. And among other things, he brought a claim of ineffective assistance of counsel at his capital sentencing, and that his counsel had failed to present relevant evidence at the capital sentencing that might have spared him the death penalty. Now, he brought a state habeas corpus action, and the state habeas court rejected his ineffective assistance of counsel claim. He appealed to the Georgia Supreme Court, or he applied to the Georgia Supreme Court for what's called a certificate of probable cause to appeal. That's a provision in Georgia law that requires a habeas corpus in order to appeal a denied habeas corpus petition. You need to apply to the Supreme Court for permission. The Georgia Supreme Court denied that application without any opinion. So there was an opinion from the lower state court that heard his state habeas petition, but no opinion from the Georgia Supreme Court, which was the final court to rule on his claim in state court. Now, he then brought a federal habeas corpus action. So again, he has to show that the state court decision was contrary to or involved an unreasonable application of clearly established federal law. But the relevant decision was the denial of the application by the Georgia Supreme Court. So how do you decide whether a decision that gave no explanation and had no reasoning, how do you decide whether that was an unreasonable application of clearly established federal law? And just as a little background, this kind of unreasoned decision is actually pretty common in lower courts of appeals, in state courts of appeals, and even lower federal courts of appeals. Unlike the Supreme Court, which largely gets to pick and choose its cases, the appeals courts often have mandatory appeals in hundreds or thousands of cases a year, most of which are completely meritless. And it's just not feasible for them to write a full opinion for every single case. So they routinely decide numerous cases with just a one-word, affirmed or reversed, and that's all you get on many cases that go through various appeals courts. So how does a higher court review this? Normally, outside of certain special areas like habeas corpus, it doesn't really matter, because the reviewing court that's looking at one of these issues can just independently decide the legal issue and doesn't need to worry about what the lower court's reasoning was. If they can just redecide the legal issue and see if if it agrees with what the lower court did. But in habeas corpus under AEDPA, because the federal court is explicitly reviewing the reasonableness of the state court's application of federal law, it matters why the state court did what it did. So there's two basic theories about what a court is supposed to do in this circumstance. One is what's you can refer to as the look-through model. And that argument is that when you have one of these, like this Georgia Supreme Court decision, which had no reasoning, you look through that unreasoned decision to the last court that issued a reasoned decision. So you'd look through to the lower habeas court, see what that lower court did, and see if that was a reasonable application of federal law. The assumption here is basically the appellate court, if it just affirms with a one-word affirmance, it was probably doing it on the same basis as the opinion below. That's the kind of assumption that goes into this. But the other model is you say, well, look, what we're asking here, and what the petitioner's burden is to show that that the state court unreasonably applied federal law. So what we have to show is, what we have to ask is whether there were any reasonable theories that could have supported what the state court did. Because if there is some reasonable theory, even if it's not the same as the lower state court, if there's some reasonable theory that could have supported the state court, the last state court's decision, then the petitioner, the criminal defendant, isn't able to show that the court unreasonably applied federal law. So that's the kind of the two basic theories. Now, Justice Breyer, for the majority, adopted the look-through presumption. And he argued basically this is a realistic approach, that the state higher courts, they will often write, denied or affirmed or dismissed when they've examined the lower court's reasoning and found nothing significant with which they disagree. That was some of Justice Breyer's language. And he also argues that this is efficient. It makes it easy to identify the specific legal theory that needs to be evaluated. It doesn't require the court to have to imagine the reasoning the state court might have, the reasoning that might have driven the state court's reasoning. Now, Justice Gorsuch dissents, and his argument basically is that the traditional rule in American courts is that unreasoned summary opinions don't necessarily express approval of the reasoning below, only the result. When a higher court just affirms with a one-word affirmance a lower court opinion, they're just saying they agree with the result that the lower court reached, not that they agree necessarily with all the reasoning of the lower court. And he also focused on the language of AEDPA, that's the federal habeas corpus law here, saying they can only overturn these lower court decisions when it resulted in a decision that was contrary to or involved an unreasonable application of clearly established federal law. So it focuses on the inconsistency of the decision, not the earlier reasoning. So that's what matters, is the decision contrary to established federal law. And it also, he notes that this is a highly deferential standard. It was intended, when it was passed, to be difficult to meet. The burden is on the habeas petitioner to show the lack of a reasonable basis. So he argues basically the court needs to determine what arguments or theories could have supported the state court's decision, and ask whether these are necessarily inconsistent with prior clearly established federal law. So, and he points out that there's a lot of different reasons why an appellate court might just affirm without agreeing. There may be one of multiple different theories that were considered by a lower court, and the higher court might agree with one of those, disagree with others, and so just that's enough for it to affirm. Or there might be a multi-part test that's involved in whatever the legal question is, that the petitioner has to meet every prong of this multi-part test. And if the court finds that there was one that it didn't meet, even if it disagrees with the lower court, then that's enough to decide the case. And he just notes that there may be a lot of costs associated with a full reasoned opinion that just outweigh the benefits of correcting tiny little errors that don't really make a difference in the outcome of the case. So he also points to kind of an unanswered question left over by the majority's opinion, which is what does a state court need to do? So again, Justice Breyer said that this is a presumption that you look through to the lower court, but that presumption is not absolute. I'll come back to that in a moment. And so Justice Gorsuch, in his dissent, asks, what does a state court need to do to defeat that presumption? For example, if a state court, instead of just saying affirmed, a one-word order just affirming a lower court decision, what if they included boilerplate language in every summary affirmance that just said, this court agrees with the result, though not necessarily the reasoning of the lower court opinion, affirmed? Would that be enough to all of a sudden defeat that presumption, or would that kind of boilerplate language leave the court in the same place it is right now? Does a lower court, if it wants to affirm but not endorse the reasoning of a lower court, does it need to use individualized language expressing that it's specifically not agreeing with a certain reasoning of the lower court? Because that gets the federal courts into the business of dictating how state courts must write their opinions, and that's something that the federal courts generally don't want to interfere with. But here, the big question here is how far apart are Justice Breyer's majority and Justice Gorsuch's dissent in practice? So I mentioned that Justice Breyer's look-through presumption is rebuttable. Now here's some language directly from Justice Breyer's opinion. He says, the unreasonableness of the lower court's decision itself provides some evidence that makes it less likely the state Supreme Court adopted the same reasoning. So if the lower court opinion that you're looking through to was unreasonable, then that in itself gets you at least part of the way toward rebutting the presumption that that was the same reasoning that the higher state court relied on. He also says, a federal habeas court may conclude that counsel has rebutted the presumption on the basis of convincing alternative arguments for affirmance made to the state's highest court or equivalent evidence presented in its briefing to the federal court, similarly establishing that the state's highest court relied on a different ground than the lower state court, such as the existence of a valid ground for affirmance that's obvious from the state court record. So again, he's giving a lot of possible sources for evidence rebutting this look-through presumption. Now, Justice Gorsuch, in his opinion, points to basically some of those same standards as what a court is supposed to look at to determine whether there is some grounds that could have supported the decision. He says the court is not supposed to just imagine new rationales, and he says, this is some of his language, what a federal court must consider is the state lower court opinion, if there is one, any argument presented by the parties in the state proceedings, and any argument presented in the federal habeas proceeding. And optionally, the court may consider other bases for denying relief that are apparent in the law and the record. So he's pointing to basically the same things that Justice Breyer suggested would potentially defeat the presumption. And he also emphasizes the majority, Justice Breyer's position that the fact that a lower court's decision is unreasonable would be grounds for potentially defeating this presumption, and kind of questions whether that kind of guts this entire look-through idea. So there's really an open question about how this case gets applied going forward and whether it actually makes any difference. Now, just as an illustration, what about the defendant in this case, this Marion Wilson, who's the criminal defendant in this case? Well, he still has an uphill climb to get his sentence overturned. So what happened in this case is here, the federal district court, when his federal habeas petition was filed, the federal district court already looked through the state Supreme Court decision, and found the state habeas court's decision was not unreasonable, and so upheld it. Now that's what the federal district court did. Now, when this went up to the federal court of appeals, the federal court of appeals affirmed the district court, but on different grounds. It said that the court of appeals shouldn't have looked through, but should have just looked for any reasoning that could have supported the state court's decision. Now the Supreme Court is saying the court of appeals did that wrong. The court of appeals should have just looked through. So it's sending this case back to the court of appeals to redo the appeal and see if the court of appeals agrees with the district court on the reasonableness of the state's look-through reasoning. To redo the appeal and see if the court of appeals agrees, and Wilson is in the exact same place. His petition is denied and he's done. But on the other hand, if the court of appeals disagrees with the district court and thinks, after when it looks through to the lower state habeas court, it thinks that the lower state habeas court's reasoning was unreasonable, was an unreasonable application of federal law, is that enough to justify them under Justice Breyer's majority to defeat the look-through presumption and then go on to consider other rationales that could have supported the decision? Because if it is, then we're right back where we started, and the Court of Appeals can just issue the exact same opinion they already issued, considering other grounds. And again, Wilson would be, his petition would be denied and he's done. So it's just not clear here. We'll just have to see how this gets applied over time. It's not clear how much difference it's going to make, and how willing lower courts are going to be to argue that this presumption of looking through the unreasoned decision, how easily defeated that presumption is. So the second case, and this case has gotten a bit of more attention due to the lineup of the justices. This is Sessions v. DiMaia, and it's a case about the immigration consequences of a criminal conviction. Now, this case was originally, when it came to the Supreme Court, it was called Lynch v. DiMaia. It was brought by the Obama administration to the Supreme Court. And it was heard, it was argued last term. It was heard by a shorthanded court, an 8-justice court. It was after Justice Scalia's death, but before Justice Gorsuch had been appointed to the court. And that 8-justice court divided 4-4. So the case was carried over for re-argument this year with a full 9-justice court. Now, it was assumed, just based on their prior positions and arguments, that the justices split along the stereotypical left-right lines. And that left the new Justice Gorsuch as the deciding vote. Now, in the decision, he sided with the liberal wing of the court. So the 4 justices that are kind of grouped as the liberal justices, plus Justice Gorsuch, made up the 5-justice majority, with the rest of the so-called conservative justices in the dissent. Now, so here's what this case is about. It's about the general issue is when federal law relies in some way on state criminal convictions. Now, the basic issue here is the vast majority of criminal prosecutions are under state law, but the federal government often wants to piggyback in some way on these state convictions. So one example is felon in possession statutes, which in determining whether someone is a felon in possession or meets certain special criteria for extra sentencing enhancements, so longer sentences under federal law, the courts will look at state court convictions. In this particular case, it's about deportation for certain convictions by an immigrant. The issue, though, is criminal laws vary enormously from state by state. They go by different names. They have different definitions. They have different punishments. There's a lot of differences in just how the criminal laws are kind of organized and defined in different states. So how does the federal law determine which state convictions count for particular federal purposes? There's various ways. Often they will define certain specific state crimes that are covered. For example, murder. You'd say murder, and then any state statute that qualified as murder could get swept in. But sometimes they use what's referred to as a residual clause. This is kind of a catch-all provision that's intended to sweep in a wider set of state crimes. Now, let me give a little more detail. The statute at issue in this case, the Immigration and Nationality Act, has a provision where an alien convicted of an aggravated felony is subject to deportation and is also ineligible for cancellation of removal, meaning cancellation of removal is discretionary relief that allows some immigrants to escape deportation even if they're eligible for it. But if someone's convicted of an aggravated felony, they're deportable and ineligible for cancellation. So that basically sets them up for definitely being deported at some point. Now, aggravated felony, what's an aggravated felony? Well, it's defined to include numerous specific crimes, but it also has this kind of catch-all where it includes a crime of violence as defined under a particular federal criminal statute. Now, that federal criminal statute defines a crime of violence. It has kind of a two-part definition. The first part is a crime where the use, attempted use, or threatened use of physical force is an element of the crime. So it's one of the things that has to be proven to convict somebody of the crime. But the second one, and this is the part that's really at issue here, is it includes a crime that, quote, by its nature involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense. And that's what's referred to as the residual clause. So how do you decide whether a particular crime fits this? How do you decide that some particular crime by its nature involves a substantial risk that physical force may be used? The approach the courts have generally taken, and this will come up again in a few minutes, is that they usually look at this not based on the specific facts of a particular immigrant's crime, but on a general assessment of the crime of conviction. So if someone's convicted of burglary, they say, is burglary the type of crime that by its nature involves a substantial risk that physical force may be used, not whether physical force actually was used in the particular instance of burglary, the particular crime that someone was convicted of. So the legal question at issue here is this residual clause unconstitutionally vague? So is this just so vague, so indeterminate, so that it leaves courts so up in the air and how to figure out what fits in this definition that it's not constitutional to apply this? Basically, can the courts sensibly determine in some kind of coherent way what crimes involve a substantial risk of physical force? So here's the basic facts. I'll run through this real quick. The criminal defendants, they're the immigrant in this case who was subject to deportation. His named James DeMaya. And he was an immigrant from the Philippines who's been a legal resident in the United States since 1992. Now, he was convicted of 2 California burglaries, and after the second one, removal proceedings were started against him. The immigration judge and then later the Board of Immigration Appeals held that the California burglary statute that he was convicted under was a crime of violence, and that means he's deportable. Now, the key precedent that the court looks at in this case is a case from 2015 called Johnson v. United States. Now, this dealt with a completely different provision called the Armed Career Criminals Act, which imposed a mandatory minimum sentence for a felon in possession of a firearm who had 3 prior violent felony convictions. But the important issue was it defined violent felonies with this residual clause that included felonies that involve conduct that presents a serious potential risk of physical injury to another. And the court in the Johnson case found that provision to be void for vagueness. So it was a violation of due process because the law was just too vague to give reasonable notice of what it covers. So Justice Kagan wrote the majority opinion in this case, and she was joined completely by Justices Ginsburg, Breyer, and Sotomayor. And I mentioned that Gorsuch was part of the majority. He only joined her opinion in part, and I'll talk about that more in a little bit. So Justice Kagan for the rest of the liberal wing of the court, plus Justice Gorsuch in part, and basically she argues that it's clear that in the criminal context, this void for vagueness doctrine applies, but also in the immigration removal context, because immigration removal is such a serious, deportation is such a serious, a severe penalty that and in many cases, for some immigrants, being deported is far more serious to them than a potential jail sentence. That this carries the same concerns, the same due process concerns, and the void for vagueness idea should apply with equal force. And she basically says that this decision follows directly from the Johnson case. The court has to imagine an idealized kind of ordinary version of the crime, and this is just something that courts just can't feasibly do. So burglary, that's the crime at issue here. It can cover a huge range of conduct with widely varying levels of risk. Justice Gorsuch, in his separate opinion, which I'll talk about later, mentioned, he says California burglary, quote, applies to everyone from armed home intruders to door-to-door salesmen peddling shady products. Just to argue that there just isn't a clear kind of idealized, ordinary version of this crime that you can obviously determine whether or not it's has this substantial risk of physical force. And also, Kagan says that, again, following the Johnson case, the idea of substantial risk itself is very vague, and that compounds the first problem. How much risk is enough for this? And the language in the Armed Career Criminals Act was serious potential risk, and the substantial risk in this statute she finds to be no more determinate than that, so it raises the same problem. And then she goes on to respond, in her opinion, to some of the dissents in this case. I'm going to talk about those dissents very briefly. There was a dissent by Justice Roberts, and he focuses on the specific differences in the text of the statute at issue here, defining crime of violence, and the provision of the Armed Career Criminals Act in Johnson, and points to the language substantial risk in this statute versus serious potential risk. It says that potential introduces more speculation about downstream consequences. The statute in this case involves the active use of physical force, whereas the Armed Career Criminals Act one dealt with risk of injury. Instead of the active use of physical force, it's a risk of injury. And so that instead focuses narrowly on the actions of the perpetrator of the crime. And also, this statute has language that says it applies in the course of committing the offense. So it's the substantial risk of the use of physical force in the course of committing the offense, and that kind of places a temporal limit around it, and says that these various kind of limitations make this more clear, and allows courts to apply this more easily. Justice Kagan responds to each of these, basically saying that they don't change the analysis. The in the course of committing the offense language goes beyond just merely satisfying the elements of the offense. So a burglary, the crime of burglary may be completely committed as soon as the criminal enters the home. But the course of committing the offense continues the entire time they're in there, and that doesn't really narrow the definition at all, because that's for many crimes, that's what the courts were looking at already under the Armed Career Criminal Act. And then also the risk of physical force. She says that the difficulty is determining what's the ordinary case, not the specific consequences, which is not as hard. And also notes that physical force is generally defined as force sufficient to cause injury. So there's not a whole lot of difference between force sufficient to cause injury and actual risk of injury. And then and she notes that there have been divisions between lower federal courts on whether specific offenses qualify as crimes of violence under this act. Now, Justice Thomas had a separate dissent. Excuse me, and he had a few different things. So one argument he made was he actually rejects. He dissented in the Johnson case. And he argues that this categorical approach, where the court doesn't consider the specific thing that the defendant, the specific instance of the crime committed by the particular defendant, but instead considers the whole, the ordinary case of the particular crime, he says that's the wrong approach, and the court should not be applying that. And he in his specific argument that in this particular immigration provision, that this categorical approach shouldn't be applied. He was joined by Justices Roberts and Alito, so the three all joined on this particular point, and said that the language of the statute didn't rule out this individualized application. Justice Kagan responds to that basically by saying that this approach was already rejected in the Johnson case, and argues that there's a Sixth Amendment problem. That's the right to a jury trial. There's a right to a jury trial problem with having it depend on the specific facts of the particular crime, whether it's a crime of violence, because this is something that's determined by a judge, not a jury. And that removes the right to have a jury determine the specific facts. Now this particular case is an immigration case where there isn't a right to jury trial, but the definition of crimes of violence is in a criminal provision that's also used in other criminal crimes. So she says it shouldn't mean one thing in immigration and the same exact language mean something different in the criminal context when it's the exact same provision of law. But anyway, Justice Thomas goes on beyond that particular criticism. He makes a much broader critique, a constitutional critique about the void for vagueness doctrine in general. And he argues that under the concept of due process just should not even encompass the idea of this void for vagueness. He has a very narrow interpretation of due process that basically says due process only requires that the government proceed according to the statutes and constitution and statutory provisions that are in place before it deprives someone of life, liberty, or property. So it's whatever rules that are in place, the government has to follow those rules. But there's no, in Justice Thomas's view, no specific requirement of what the law must be. Just that whatever that law is, the government has to apply it. And under that interpretation, vagueness just doesn't matter. If there's a vague law, the government has to follow it. But there's no requirement that would allow. There's no requirement kind of policing the terms of the laws that the government does have in place. And he has a few other similar kind of constitutional concerns in that respect. Now, the interesting thing here, now I'm going to go back to Justice Gorsuch. He issued a concurrence. He joined most of Justice Kagan's majority, but also had a separate concurrence. And part of his concurrence was directly responding to Justice Thomas's position, and he goes through kind of an extensive his own historical analysis. So you have these competing historical analyses going through early American history and early case law and some of the predecessors to the American due process concept, coming to different conclusions on it. And Justice Gorsuch concludes that that the due process is broader than Justice Thomas's version of it, and says that someone is entitled at least to the customary procedures to which people were entitled under the laws of England, which include fair notice, which has been defined in cases as precise and sufficient certainty about the charges someone's subject to. And he points to a long history of treating various vague statutes as basically nullities because they were too vague to be determined. And so he kind of has that argument with Justice Thomas. Now, the interesting thing here is he rejects, and the part of Justice Kagan's decision that he did not join was he rejects the distinction between, for purposes of this vagueness doctrine, between most civil actions, and criminal actions. Now, Justice Kagan's decision basically said deportation is serious enough that we can group it with criminal actions for purposes of having a very strong vagueness doctrine. But Justice Gorsuch argues there's no reason to differentiate between the two. He says some civil laws impose harsher penalties than many criminal laws. Sometimes even the same conduct can have extremely onerous civil penalties, but relatively speaking, mild criminal penalties. And he points to things like confiscatory fines, property forfeitures, loss of professional licensures, and even involuntary commitment as civil penalties that are, can result in extreme loss of liberty or property. And so he argues that actually he would have a much broader version of the void for vagueness doctrine than the rest of the justices in the majority. And finally, interestingly, he says that the majority should reserve its judgment on the ordinary case, the categorical approach versus a case-by-case inquiry as far as the residual clause is concerned, because he says no party to the action, meaning basically the U.S. government, didn't argue otherwise, and so the court should. It's really, the issue is not presented in this case. So that's kind of the scope of this case. It's just an interesting lineup, an interesting historical argument between Justices Thomas and Gorsuch, and an interesting kind of sign of where Justice Gorsuch kind of how he views these issues, particularly in the criminal and immigration context. So anyway, that's the two new opinions for this week. Now that took a while, so I want to very quickly try and run through the cases the court's going to hear next week, just for purposes of time and keeping this short. I'm going to go very quickly through these, but again, there's 6 cases, and I'll just try and give a very brief idea of what each one is about. Now, the first case on Monday, the court will be hearing 3 cases. The first case is called Lucia v. SEC. That's the Securities and Exchange Commission. Now, I've heard this case pronounced Lucia. I'm going to go with Lucia. I don't actually know which is the correct pronunciation, but this is a case that's basically challenging the legality, the constitutionality of the appointment of the SEC's administrative law judges. Now, administrative law judges, called ALJs for short, are agency officials. They're not judicial officers. They're not members of the judiciary, but they're agency officials that have a judge-like function. They have trial-like adjudications, and they hold hearings and adjudicate matters within the agency. Now, the issue here is that the Constitution establishes the methods of appointing officers of the United States. And there's specific provisions. It depends whether someone is what's referred to as a principal officer or an inferior officer. But basically, assuming, because this is the issue that's being argued in this case, assuming someone's an inferior officer of the United States, they either have to be appointed by the president and confirmed by the Senate, or Congress can pass a law that that vests their appointment in the president alone, or the courts, or the heads of departments. Being the heads of departments, meaning like a cabinet secretary or someone who's in charge of the particular department. Now, apart from these officers, there are employees. That's just a separate category. These are people that are hired, not appointed, but hired just through a normal hiring process. Now, some cases challenge the line between a principal officer and an inferior officer. This case is the question between officers generally, so an inferior officer at the bottom, and mere employees. And the challenge here is that the ALJs at the SEC were not appointed by the commission. Now, the commission, that's the actual commissioners who are at the top of the SEC. They would be the heads of the department who under the Constitution could be given the authority to appoint inferior officers. They're not the ones who had selected the ALJs. Instead, they were selected by certain SEC staff. So the argument here was that this was just unconstitutional, these appointments. Now, the party in this case, Lucia, was an investment professional who had been charged with the SEC by the SEC with fraud in presentations to potential clients. He was tried before an SEC ALJ, administrative law judge. He was found guilty and had some pretty severe consequences. He was stripped of his license, barred from the industry, and fined. Now, he argues that the charges were flawed and unfair, and he shouldn't have been convicted. But in any case, he brought a challenge against the constitutionality of the ALJ's appointment. The ALJs exercise broad discretionary authority. It's similar to a judge in many ways, but their decisions are subject to review by the commission, the SEC commissioners. Interestingly, in this case, the U.S. government, now this was a change in position after the Trump administration took over. The U.S. government now supports Lucia in this case, and says that the ALJs are officers who were not constitutionally appointed. So there's a question here: who is an officer? Lucia argues that it's a pretty broad definition. Anyone who's exercising an office established by law and exercises significant federal authority is an officer. Now, as I said, the U.S. government is no longer defending the other side of this case, so the court appointed an amicus, that's a friend of the court, an outside attorney, to defend the position below, to defend the position that these are not officers who needed to be appointed under this constitutional provision. And so an attorney named Anton Metlitsky is arguing the other position, and he argues for a much narrower definition of officers. Says it's only someone who can bind the government in his or her own name, so not someone who has who's just exercising the authority of some superior, but someone who under law is specifically given by virtue of their position the power to bind someone in some way. And he also says that ALJ decisions are not final decisions. They must be approved by the commission. And so all the accountability rests with the commission, and that kind of satisfies the whole purpose of the appointments clause in the first place. The accountability is with the officers who are appointed under the constitutional procedures. Excuse me. There's also a dispute over the remedy here. So even if these administrative law judges were unconstitutionally appointed, well, what do you do about it? So the SEC, after President Trump took office and changed the position, the SEC issued an order ratifying the previous appointment of the ALJs. So they said, we as a commission now ratify their appointment. Now, Lucia says that this doesn't provide him any redress. That doesn't fix the problem that he was tried and convicted by an unconstitutional ALJ. He argues that he needs an entirely new procedure. The previous proceeding was a legal nullity and can't be retroactively made legal, and the ALJ that heard it is kind of tainted by participating in this unconstitutional proceeding. And he also argues that dismissal is really appropriate because the SEC's ratification order shows it doesn't take seriously the constitutional issue involved, and the SEC intends to return the case to the prior ALJ to just rubber stamp the previous work, and that's what has been done in many other cases similar to his. So he argues that due to kind of the circumstances, it would be appropriate to just throw his case out. That's his argument there. And just some context here. There's a huge variety of different theories on what the test for officer should be, and the Supreme Court's case law doesn't really is not particularly satisfying. There's several cases that have touched on this that kind of don't give one clear line. There's a lot of interesting historical arguments going in various directions on exactly how the court should draw this line. And the potential implications of this case, depending on how the court decides it and exactly what they say about who is and isn't an officer, could have a huge implication on numerous different agencies. Many different agencies have their own ALJs, and this decision could potentially reach much further than just ALJs to a lot of other federal employees. But again, it totally depends on how broadly or narrowly the case court decides this case. So moving on, the next case also going to be argued on Monday is called Pereira v. Sessions. And this is a case about the Attorney General's ability to cancel removal procedures against a deportable alien. So the issue is, say someone is an unauthorized immigrant, and they are subject to deportation. There are provisions where they can seek cancellation of removal. So that's a discretionary process where their removal can be canceled and they can be given a legal status to remain in the United States. One of the conditions for being eligible for that discretionary procedure is that they had to have resided for 10 years. They had to have 10 years of continuous presence in the United States. The issue here is there's a provision known as the stop time rule, which basically says once the immigrant receives notice to appear for removal proceedings, then the clock stops for purposes of accruing 10 years of continuous presence. And the purpose of this is it was to prevent an immigrant who's been served with a notice that they're going to be, the removal proceedings are going to start. It's to prevent them from doing everything they can to delay the proceedings, drag their feet and delay the proceedings in order to gain more time to meet this 10-year eligibility. So basically, suppose someone's been in the country for 8 years, they get served with a notice of one of these notices that there's going to be removal proceedings. Then the clock has just stopped. They only have 8 years. They can never meet that 10-year requirement, and they're not eligible for this cancellation. Now, the issue here is that there's a particular provision that defines requirements for the notice referred to as a notice to appear, the notice that kind of stops the clock. And there's various requirements that have to be included in this notice. And one of them is the time and place at which the removal proceedings will be held. Now, here's the issue. Pereira, that's Wesley Pereira, entered the United States in the year 2000. He was served with a notice in the year 2006, but that notice had no date or time for the removal proceedings. Now, he was eventually in 2013, he was detained by DHS. Now, 2013 is more than 10 years of continuous residence, so he could potentially be eligible for cancellation. He applied for cancellation, but this was denied because they said that the notice served in 2006 stopped the clock. and so he didn't have 10 years. Now, DHS, the Department of Homeland Security, has a practice of routinely sending these notices without any date and time. And according to DHS, that doesn't matter as long as they send the notice. The notice is what stops the clock. It doesn't matter if it has some technical defects or is missing some information. But sometimes they follow up with deportation proceedings, sometimes years later after this notice is served. If the clock had been allowed to run, cancellation might be cancellation of removal might have been a possibility in some of these cases. Now, Pereira argues the statute is clear. It says that basically the notice to appear provision is basically definitional. It's kind of defining what it means for something to be a notice of to appear, and one of the criteria is that it includes the date and time. So if something doesn't have the date and time of the removal proceedings, it just isn't a notice to appear under this statute, and therefore doesn't stop the clock. Now, the government, on the other hand, argues that the reference to that notice to appear is just intended to kind of identify the type of notice that has to be received in order to stop the clock, and it wasn't meant to mandate that every single requirement on there has to be met. And they say this is immaterial and doesn't affect whether the clock is stopped. Now, move on. The third case of the day on Monday is called Chavez Meza v. United States. Now, interesting note about this case. This case is scheduled to be argued for the United States by the Deputy Attorney General Rod Rosenstein. Now, apparently there's a tradition that presidentially appointed officials at the Justice Department are allowed to argue one Supreme Court case basically as a courtesy. Normally, all of the United States' arguments at the Supreme Court are handled by the Office of Solicitor General, which is a special division inside the Department of Justice that handles the Supreme Court. But other high Justice Department officials are allowed this courtesy of arguing one case, and this is Rosenstein's case. Now, he's obviously been in the news recently as a target of President Trump's ire due to his role with respect to the Mueller investigation. And there's been a lot of speculation about what the Solicitor General's office would do in the event of a last-minute firing shortly before the oral argument. But hopefully we won't have to find out how they would deal with that. Now, the issue here is it's about federal sentencing guidelines. Now, in the federal courts, there's a set of sentencing guidelines that calculate a range of time that someone should spend in prison for a particular crime based on a variety of factors. Now, the way it works is when someone is sentenced for a federal crime, the sentencing court has to calculate a sentence under these sentencing guidelines. This guideline sentence range, it provides a range of months, and this range isn't binding on the court, but it's highly influential. Now, it creates a starting point. Courts can depart up or down from that range from the guidelines, but they have to calculate it, and it provides kind of a very important starting point, and many sentences are within that range, or at least start from that range as a starting point. Now, what happens if a sentencing range is later lowered? So the United States Sentencing Commission is in charge of establishing these guidelines, and sometimes they decide that a previous sentencing range is too high and should be lowered. Now, there's a provision that says a court can consider a reduction if someone is sentenced and they're given a particular range of months under the sentencing guidelines, and the guidelines that they're sentenced under are later lowered so that the sentence that's recommended would be lower, then the court can consider certain factors and sentence them to a reduced period of time. But this statute that allows this resentencing, it requires the court to consider certain specific factors in their resentencing, but doesn't explicitly say that the court has to explain how it's applying that factors or why it's resentencing the way it is. Now, what happened in this case is Chavez Meza pleaded guilty to possession of methamphetamines with the intent to distribute. And his guidelines range, which is largely based on the quantity of the drugs involved, was 135 to 168 months. Now, that's about 11 to 14 years. The judge sentenced him to 135 months, which is the bottom of that range. This range was later amended, so instead of 135 to 168, it dropped down to 108 to 135. He requested that he have a proportional adjustment and be dropped down to 108 months, which is the bottom of the new range. Instead, the judge reduced his sentence only to 114 months. Now, it's still within the new range, but he was at the bottom of the previous range. Now he's somewhere in the middle of the new range, and there was no explanation of why that change was made as it was. He argues that that the requirement that the court consider certain specific factors in the resentencing just implies that the court has to indicate how it's using those factors, because otherwise, he says, appellate review is effectively unavailable. An appeals court is just has no way of making sure that the lower court is doing what it was supposed to do and appropriately considering the various factors involved. The government on the other side says, no, the statute doesn't require, unlike the original sentencing where the statute specifically requires an explanation, the resentencing statute doesn't require that. The appellate courts regularly review decisions that are made without explanation. For example, during a trial, various evidentiary rulings will be made on the fly with no explanation, and courts regularly review those. And also, a range that's within the guidelines just doesn't require any explanation. The original sentence, the reasons given for his original sentence could have easily justified a sentence that was 6 months above the bottom of the range, just like the 6 months above the bottom of the range that he has now. So there's really no need for the judge to give any more explanation. That's the government's argument, basically. So let's move on. A couple more cases. I'm going to try and move, again, quickly through all of these, just because this is already getting a little long. But the first case on Tuesday is called Abbott v. Perez. Now, this is two consolidated cases out of Texas that are challenges to Texas's electoral maps as illegal racial gerrymandering. And the basic facts of this case are this: there's two challenges. One is to the several federal congressional districts, and one is to a state House district. Now, in 2011, Texas enacted new electoral maps after the 2010 census. This plan was challenged. There was various allegations of racial gerrymandering in various districts. In 2012, while the litigation was ongoing, the district court that was overseeing, the federal district court overseeing that litigation, drew up an interim plan for the 2012 election, just to have a plan in place for the 2012 election. And it carried some of the districts over directly from the 2011 map, but made some other changes to cure what it identified as racial gerrymandering problems. And this was not a final court decision, but it was kind of an interim decision while the case was ongoing. Now, in 2013, the legislature basically just adopted the 2012 plan that the court had put in place for the 2012 election. So they officially adopted that as their own plan with some minor changes that aren't really relevant here. The litigation continued after that. And what happened and what brought this to the Supreme Court is in 2017, the federal district court found that the 2013 plan was tainted by racial motives behind the 2011 plan, and found that three particular districts were unconstitutional racial gerrymanders in various ways. And so this is up to the Supreme Court. Now, there's an interesting thing. These particular types of these election redistricting cases, there's a unusual procedure where in federal courts, instead of being heard by one trial judge, they're heard by a panel of three trial judges, three district judges. And then there's an ability to appeal those decisions directly to the Supreme Court, bypassing the courts of appeals entirely. There's a first issue in this case, whether the Supreme Court actually has jurisdiction to hear this case. Now, the odd thing about this is that the district court in this case declared the existing maps invalid, but didn't explicitly enter an injunction, like an official order ordering Texas to do anything. Texas says this is functionally an injunction because it basically prevents Texas from using the old map and requires them to draw up new maps before the election, even though the court hasn't explicitly ordered that. So it's close enough. Now, the issue is the court only has jurisdiction to hear these appeals directly from these three-judge panels when those panels grant or deny an injunction. Now, usually that's exactly what's happening in these election redistricting cases, but technically there's no injunction here. So there's an issue of whether the court even has jurisdiction here. But on the merits, the basic argument here is the argument by the challengers to these districts is that there was a discriminatory intent present in 2011. And then when those same districts were adopted in 2013, unchanged from the 2011 map, those districts were continuously enforced from 2011 on. They were unchanged. And so any racial animus that affected the 2011 line drawing is still there with respect to the 2013 map. Now, Texas argues, on the other hand, that in 2013, the legislators very explicitly relied on the district court's rulings that this 2012 map complied with the various legal requirements. And so they say, look, the legislatures in 2013 wanted to avoid all this litigation over racial gerrymandering. The 2012 map had been put in place by the court, so they chose to just adopt that as their map. And the challengers say, well, they're just trying to shield their 2011 misdeeds by by virtue of having snuck this past the court in 2012, they shouldn't be immunized from the bad intent that was behind the 2011 map just because the court in 2012 didn't happen to fix all of the problems. So that's kind of the basic main legal issue there. So the second case on Tuesday next week, this is actually my favorite case of the cases that are going to be heard this week. It's kind of a very odd circumstance. So here's the issue. In a number of different circumstances, a case that's in American court might depend in some way on the law of a foreign country. So for example, there are U.S. laws that criminalize importing certain goods into the U.S. in violation of the laws of the country of origin. Well, in order to convict someone of that, you need to determine what the laws are of the country of origin that were supposedly violated. Here's another example. Imagine, for example, there was a contract that required a party to transfer certain property located in Ontario in accordance with Canadian law. And then there was a suit for breach of contract. The court might need to determine whether Canadian law was complied with in order to determine whether there's a breach of contract. So how does a court figure out what foreign law requires? And what if we're not talking about Canada, which at least has a common legal tradition with the United States and has legal resources widely available in English? But what if instead we're talking about a country like China, where all of the primary legal authorities are in a different language with very limited resources in translation, and the legal and political systems are extremely dissimilar from the United States? Now, the broad question is, how does a court determine the law of a foreign country? And there's some guidance to this in a federal rule of civil procedure. It's Federal Rule 44.1. This is a rule of conducting civil cases. It says, in determining foreign law, the court may consider any relevant material or source, including testimony, whether or not submitted by a party or admissible under the federal rules of evidence. So basically just saying a court can consider anything, but it doesn't tell a court how much weight to give it, any particular type of evidence. Now, the more specific question here is, when a court is determining what the law is of a foreign country, how much weight should a court give to assertions about that law from official agencies of that foreign government? So here's this case particularly. The company called Animal Science Products, they sell vitamins, and they brought an antitrust action against 2 Chinese vitamin manufacturers, and they allege that they're engaged in illegal price fixing. Now, the Chinese vitamin manufacturers, they argued in their defense, they argued that this price fixing was actually required under Chinese law. Now, what happened is a Chinese government agency, specifically the Ministry of Commerce in China, appeared in the district court, the trial court, as an amicus, as a friend of the court, and told the court that, in fact, this price fixing was required under Chinese law. Now, the district court didn't believe this representation from the Chinese government and said, based on contemporaneous evidence, it didn't believe this was actually the case, and found that denied this defense, that it was refused to dismiss the case on the basis of this defense. Now, the Court of Appeals overruled this and basically said, in this situation, when the foreign government actually appears in litigation, deference is required. If China hadn't appeared as an amicus, a friend of the court, in the litigation, then the district court's careful balancing would have been appropriate. But in this case, where the foreign government actually came to court and told the court what the right interpretation was, the district court had to defer to that interpretation. So the question here is that right? Must courts defer to a foreign government's interpretation of its own law? Now, on the one hand, the argument is, well, they have expertise. They understand the legal context, the language, the interpretive practices of that particular country. So they're in the best position to be able to actually explain what the law means. And also, there's an issue of what's referred to as comity. Comity, that's C-O-M-I-T-Y. Is the idea that countries should give a level of respect to foreign sovereigns and avoid creating international tension by insulting or disregarding foreign laws or foreign governments. And this concept of comity suggests that you should defer to the foreign government. Now, on the other side, there's the argument that foreign governments sometimes have ulterior motives. Here, the argument is that the Chinese government is just trying to protect these Chinese companies from legal liability. And specifically, Animal Science Products, in its briefs, it paints a pretty ugly picture of a Chinese government agency allegedly colluding with these Chinese governments to willfully and egregiously misrepresent Chinese law in order to shield the companies from liability. Now, it just raises some very interesting questions, and there's some interesting comparisons to American law and how the courts deal with U.S. agencies who come into court and want to argue specifically what the law is that should apply, and there are some legal doctrines that go kind of broadly under the labels of Chevron deference and Auer deference, that in many circumstances require courts to defer to an agency's interpretation of laws that agency administers. But it's far from absolute. Courts don't just accept the agency's assertions; they scrutinize them and make sure the agency's interpretation is otherwise consistent with the law. And there's various checks on it, and it's not at all unusual for a U.S. agency to come to court and say, "This is what the law that we administer means," and have the court basically respond, "No, it doesn't. You're wrong." So it's kind of odd if the argument is that a foreign agency gets even more deference than a U.S. agency would in U.S. courts. But on the other hand, there is a real problem of expertise in trying to understand foreign law. Even when we're talking about domestic law, especially complex regulatory regimes, sometimes it's incredibly challenging to figure out the correct interpretation. There's specialized terminology. There may be overlapping regulatory schemes. There may be case law interpreting particular provisions in counterintuitive ways. And there may be, in some cases, regular agency practices that are at odds with the official procedures on the books. And we add to all that an unfamiliar government bodies and unfamiliar legal codes, and only having secondary sources and imperfect translations, then there's a real question of whether courts should be in the business of second-guessing an official foreign government's pronouncement on what its law is. One interesting note in this case: the Ministry of Commerce for China is actually being allowed some argument time at the court. It's very unusual. The court rarely allows, other than the U.S. government, rarely allows amicus parties to actually argue at oral argument. And this is kind of an example of the comedy concept that they're giving the government of China kind of special consideration in actually getting to directly participate in the proceeding. Anyway, moving on to the last case that will be argued next week on Wednesday, and this is Hawaii v. Trump. Now, this is the case, the travel ban litigation, the case about the challenge to the President Trump's proclamation that barred entry into the country from nationals of certain countries. This case, the litigation right now it focuses around what was the third version of the travel ban order, and this was issued in September. This was the third version. The earlier versions of the travel ban were explicitly temporary, and they were set to expire. And on the expiration of those earlier versions, this was put in as the permanent version of the travel ban, and that's the one at issue in this particular case. And there are several different arguments that are in play, and I'm going to run through them extremely briefly. One is a statutory argument, and the argument is the president lacked the authority to bar entry from nationals of the countries in question because of a provision of law that specifically bars. Here's the language. No person shall receive any preference or priority or be discriminated against in the issuance of an immigrant visa because of the person's race, sex, nationality, place of birth, or place of residence. And the argument is nationality is specifically included in that, so there should be no discrimination on the basis of nationality. So this bars the president's action. The argument on the other side is there's another provision of law that gives very broad authority to the president to exclude people from entry into the country. And it basically says, whenever the president finds the entry of any aliens or any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. So it's an extremely broad delegation of authority to the president to deny entry to certain people. And so that's kind of a clash of these two provisions. The government argues that the non-discrimination provision applies only to the issuance of immigrant visas, which is just one category of visa that is issued, and doesn't deal with the issue of entry into the country, which is a separate concept from issuance of a visa, and so that these two provisions don't actually conflict. And they cite some historical precedents that they say justify this kind of a ban. But in addition to the statutory argument, there's also a constitutional claim, and the claim is that this travel ban is a violation of the First Amendment's Establishment Clause. That's the First Amendment provision that prohibits preferential treatment of provisions. The argument here is that this travel ban was motivated by President Trump's anti-Muslim animus, and this is demonstrated by Trump's public statements, including during the presidential campaign, specific statement saying that he wanted to shut down all Muslims entering the country. Now, the government argues that this is in fact the result, especially this latest version of the travel ban, as a result of a neutral review program that required information from various countries around the world and assess them on their ability to provide adequate information about their nationals who were traveling to the United States. And that in their latest version of the travel ban, they dropped certain Muslim countries from an earlier version of the ban after the review, and added and dropped certain categories of entrance from other Muslim countries, so that this wasn't motivated by anti-Muslim animus, but by the fact that certain countries just don't have adequate protections to allow the United States to be secure in who is the identities and backgrounds of people that are entering the country. So that's the kind of in brief the constitutional argument that's going on. There's actually a side kind of procedural issue in this case also, that it would be that the court had specifically granted as an issue that it was going to address, and this is an issue about nationwide injunctions. So in the travel ban case, and this has been a regular feature of much of the litigation against the Trump administration. Now, it wasn't new. This was kind of a trend that started under President Obama, but has accelerated and become extremely common in litigation against the Trump administration, where actions are taken challenging lawsuits are brought challenging actions of the administration, and courts have issued injunctions that don't just apply to the specific parties involved in the case. So the travel ban litigation, the injunctions that were issued didn't just apply to the specific immigrants who were challenging the travel ban, but they were applied nationwide to everyone across the country. Now, the argument is that traditionally injunctions only bind the specific parties to the case. There are separate class action procedures that exist to challenge on behalf of all people who are affected, but class action procedures have very specific procedural requirements that have to be followed in order to certify a particular class. And nationwide injunctions, the argument is, are just bypassing these procedural protections and kind of ignoring normal rules of who can be bound by an injunction, or how broadly an injunction can be issued. The Supreme Court has taken cases in the past that involved nationwide injunctions, but has never specifically addressed the issue of the appropriateness of nationwide injunctions, or how they should be used. So here they specifically granted a question about the proper scope of the injunction. So this may be an issue that the court has finally decided to weigh in on. So that does it for next week's arguments. And again, next week is the last week of oral arguments from the term. So from here on out, it's just going to be basically opinions, all those 45 cases that the court has to decide between now and the end of June. Our next live stream will be a week from today. That's Thursday, April 26th, again at 9 p.m. Eastern time. That's our usual weekly live stream time, Thursdays at 9 p.m. Eastern. And you can always check the Counting to 5 YouTube channel for the next scheduled live stream. Next week's live stream, tomorrow, that's Friday, April 20th, the court has another of its private conferences. So there's, again, a chance of some new granted cases on Monday morning's orders list. It seems like there's a high likelihood that we'll get one or more opinions next week, just because there's such a backlog and we're getting toward the end of the term. And so if that does happen, that will likely happen on Tuesday or Wednesday at 10 a.m., just immediately before the day's oral arguments. So we'll see if we get some more opinions next week. And of course, there's always a possibility of emergency orders or other interesting developments. Whether you're watching on YouTube or listening to the audio podcast, I would love your feedback. You can leave comments on the show notes at countingto5.com, on the Counting to 5 YouTube channel or Facebook page. You can tweet at countingto5 or send an email to mike@countingto5.com. Please subscribe to the Counting to 5 YouTube channel or audio podcast to make sure you don't miss future episodes. And thank you for listening. This has been Counting to 5.